people. And they held true to this general authority by retaining for themselves the specific power to amend the Constitution. Now, the court has consistently protected this right against nullification, subject to the legislature's authority to dictate the form of the petitions necessary to put a question on the ballot. The legislature did specify the form, and in doing so, it was in painstaking minutia. It detailed the required page size of the petition down to the half inch, mandated several font sizes applicable to different aspects of the petition, and dictated certain language that must be used on the face of the petition. But the legislature made no mention whatsoever of spacing within the text appearing on the petitions, which is the basis of the challenge to the RFFA petition. So absent a constitutional or statutory deficiency, the Constitution requires that the valid proposal appear on the ballot. Yet, the Board of State Canvassers, which again is a ministerial body without any legal powers or judgment of its own, effectively usurped the legislature's authority by refusing to approve the petition, ostensibly because two of the board's members thought the word spacing was insufficient. And they effectively created and applied legislation of their own. And by aggrandizing itself, this unelected board has treated the Constitution of this state as an advisory document, and it's stripped the people of their right to amend the Constitution. And as such, we join in asking the courts to issue a writ of mandamus to essentially force the board to certify the language of this ballot proposal so that the ballot proposal can then appear on the November ballot. So with that, I'm happy to take any questions.
I see Alex Ebert from Bloomberg first with a question, AG.
Great. Hi, Alex.
Good morning, Attorney General. My question is a little bit sticky here, and that's what is sort of the last moment at which we could get a decision from the court? Courts have extreme power to put people on ballots, move elections if they need to, but do we need to get some sort of ruling before the meeting on Friday of the Board of State Canvassers in order to get this on the ballot?
Yeah, my understanding is that really the latest that we could receive a court ruling on this would be tomorrow. This all has to be done by first thing in the morning on Friday, September 9th.
Thank you, Alex. I'm going to move to Beth LeBlanc and then Allison Donahue next.
Attorney General, when you filed the amicus brief, did you have to create? I guess I'm wondering who represents the Board of State Canvassers. Is it your office? And if so, did you have to create kind of a firewall between the two sides in that sense?
Correct. I created a conflict wall, and yes, my office is continuing to represent the State Board of Canvassers and also the Secretary of State. But as you know, Beth, I in my parents' patriotic capacity, I have the ability not just to represent the state of Michigan and its various boards and commissions, but also the people of the state of Michigan. And so I erected a conflict wall so that I could make this argument on behalf of the some 750,000 people, 600,000 of which were confirmed as valid signatures. And the overwhelming majority of people in the state of Michigan that want to have the ability to vote on this very, very important ballot proposal.
Thanks, Beth. I'm going to move to Allison, and after Allison to Dave from the Free Press.
Hi, thanks for taking my question. I was wondering what is possible for this proposal if the Supreme Court blows past the Friday deadline?
Well, the only thing I can think of if that happens is that there could be an argument that it would appear on the ballot in 2024, because certainly there wouldn't be the opportunity for this to be on the ballot and be voted on by the people for the November 2022 election. If I'm wrong about that, I'd love for my chief deputy to correct me. Christina, are you on here?
Yeah, I'm on. I mean, I think the court can always order that changes be made to the ballot, but practically speaking, that's difficult when ballots have already been sent out for absentee voters and overseas voters. I'm pretty confident the court understands the deadlines and will meet the deadline that the secretary has requested.
Thank you, Allison. I'm going to move on to Dave now from the Free Press with a question.
Hi, thank you for doing this and for taking my questions. Attorney General Nessel, I'm wondering if you could weigh in on what sort of precedent you think the court would create if it does not require the Board of State Canvassers to put this on the ballot? And more broadly, do you think that the Board of State Canvasser process is broken?
Yeah, thanks for that question, Dave. I think this sets the most dangerous precedent I can possibly imagine. You know, for many years, of course, the system has for the most part worked, and it's worked well, and litigation has been avoided this way. And I really can't speak to the intent of the creation of the boards of canvasser and the state board of canvasser, except for, you know, they wanted to have, you know, different parties who could mutually agree on the fact that all of the elements laid out by the legislature had been met. And of course, in this case, there's no argument that the specific elements that the legislature has required the State Board of Canvassers to look at have been met. But then here, of course, they have created their own brand new requirement that is not within their purview. And that is, of course, this alleged spacing issue. So really, if you have these two members of a board, neither of whom were elected by anyone, right? They are appointed after they've been selected by a particular partisan political party. It would really say that you know, these two unelected members of the Republican Party could not just usurp the legislature in terms of the powers that were provided to them, but really would, you know, thwart the will of hundreds and hundreds of thousands of people in the state of Michigan. And I can't think of anything more undemocratic than that. And I think the precedent would be set here essentially is that any time one of the political parties decides that they don't like a ballot proposal and they don't want it to appear on the ballot, either because, and let's be really honest about this in this particular election, either because they don't want the ballot proposal to pass, or they don't like the fact that it's likely that it will generate increased turnout. But anytime you have a political party that, or even just a couple members of a political party that make that decision, somehow their decision is more important than the decision that was made by hundreds and hundreds of thousands of people when they decided to sign on to this. And I will say a couple of things about what a great threat that is. First of all, I think that if the Board of Canvassers is allowed to get away with it this time, when I say the board, I mean the two Republicans on the board, then they're just going to continue to use this every single election with every single ballot proposal, and potentially more than that, right? We're also talking about the certification of you know, candidates to appear on the ballot, and then later on, whether or not those candidates are deemed to have won their respective elections. So I think it sets the most dangerous and ugliest precedent I could possibly imagine. And I think that's what's so offensive, really, in this set of circumstances, is that you're literally saying that that, as the Republicans on the board have said, that a spacing issue or a typographical issue should supersede what so many people in this state deem to be a fundamental right. I can't think of anything more offensive and disturbing than that. And I will just tell you a story. I was just talking to a gentleman last night who's from northern Michigan, and he and his wife really wanted to support this ballot proposal. They, like many people, knew what this ballot proposal was about, and they supported reproductive freedom and was very, very upset about the current state of affairs in regard to the United States Supreme Court's overturning of Roe v. Wade. and they wanted to do something about it. They wanted to take action, but there was no one in their town who had been circulating this ballot proposal. They couldn't find it anywhere, even though they actually called the organization that was sponsoring this. So they drove an hour in their car each way. They drove an hour to get to a city where they knew that the ballot proposal was available and being circulated so they could sign it. And then they drove an hour home. That's how strongly people feel about this ballot proposal. So to have these two members of this board say, well, we don't think that the voters should even have the opportunity to vote on it because we decided that we don't like the spacing issue, even though that's not even something that's within their purview. I think it sets the most dangerous precedent I can possibly imagine. And if you're asking me, does this mean that maybe these boards of canvasser, and especially the state board of canvasser, has outlived its purpose or no longer is fulfilling its purpose? I absolutely think that's something that the voters of the state should evaluate. This is constitutional in nature, so there would have to be a constitutional amendment to have a new procedure put into place or to eradicate it. But all of our election system, like literally almost every portion of our system of elections, relies on having members of different political parties that come to a consensus, whether it's an individual ballot or whether it's certification of the individual who runs for president of the United States by the State Board of Canvassers. This is really concerning. And to have the courts have to weigh in on every single solitary issue, I don't think is something that our Constitution ever really contemplated.
Thank you, AG. I'm going to move to Ben from Gongwar, and then Stella at Bridge. You'll be after Ben.
Good morning, Attorney General. It's always tough to read the tea leaves, I know, with the Supreme Court, but what do you think the majority is poised to do here? And more specifically, do you think that the Democratic Party majority on the bench will take your side, or rather be advantageous for the reproductive freedom for all people?
I think all 7 justices on the Supreme Court should rule in favor of, a writ of mandamus in order to ensure certification on this. I think that is the right thing to do. Whether different, listen, clearly our Supreme Court involves, even though they're technically nonpartisan, obviously those individuals are nominated by a political party. So it is hard to completely remove any partisanship. But what I can say is this: if there are, say, those who are on the court because they were appointed by a Republican governor, or they were nominated by a Republican convention, I think they really have to think more than anything about what does this mean if the Democrats are also able to engage in this kind of activity. So once you set that precedent and you say, yes, we are going to allow the Board of Canvassers to basically become legislators and judges. And they're going to have the ability to make these decisions, not just the legislature, not just the courts. Then that's something the Democrats can do as well. And I don't think anyone wants to see this happen. That's why these issues are decided by the courts. And let me say something else. What's so rare is that, generally speaking, a court will not weigh in on a law and the substance of a law until or unless it actually becomes the law, right? So if you have legislation that is pending in the state legislature, it's pending in committee, or it's being voted on in the House, or it passes in the House and Senate, but it hasn't been signed by the governor yet, or it even hasn't taken effect yet, generally speaking, the court won't even weigh in because it's not really a law yet. And they're not going to look at something that is not yet a law and decide from a substantive viewpoint whether or not it meets the threshold of, statutes or constitutionality. And there's all kinds of rules of interpretation and construction that are utilized, again, by the courts, not by the State Board of Canvassers. So for the State Board of Canvassers to interject themselves in this way and to say, you know what, don't worry, Supreme Court, don't worry, legislature, we got this. We're going to make this decision. I just think that both for those who are on the court that, came from the Democratic Party or the Republican Party, it's too dangerous of a precedent to set. And, what's good for the goose is good for the gander. And I don't want to see either political party use this kind of gamesmanship to keep important ballot proposals that enjoy such a significant amount of support off the ballot. I think it erodes democracy in our state significantly. It's very dangerous.
Thank you, Attorney General. Stella, to you, and then Omar, you will be next. Thank you.
Hi, Attorney General. Thanks for hosting this press conference. So I have two questions related to the proposal. So first of all, just following up on what you just said, is it possible for the court to hold off on ruling before Friday until the issue is actually on the ballot and becomes law, and then they would weigh in? Like, has that ever happened?
Well, it won't be on the ballot unless the court rules, because the Board of Canvassers, you need to have at least 3 votes in order to certify the petition. And they deadlocked 2-2. So that's why the court must intervene. If the court does nothing, then this proposal doesn't appear on the ballot.
Gotcha. Thanks for the clarification. The second question is, so is there a distinction between what happened to the 2002 drug law proposal, where there had been an apparent typo issue and it was kept off the ballot? How is it different from the spacing issue this time? Can you elaborate? Thanks.
Sure, that's a good question. Christina, I wonder if you could weigh in on that. You might have more familiarity with that.
I'm sorry, I can't. I'm not familiar enough with the 2002. So I can't compare the two.
What we'll be happy to do, though, is if we could respond to you in writing and send an email once we have an answer to that. I'd be happy to do that.
Sure, that'd be great. Thanks.
Sure, we'll get on that right away.
Yeah, thanks, Stella. I'll send you an email so I can get a follow-up for you. And Omar?
Hey, Attorney General Nessel, thank you so much for doing this. I think really just generally outside of the judicial process itself, and given obviously the status of abortion rights federally, can you speak just to the importance of allowing Michiganders to potentially just vote for themselves, given the climate, of course, nationally?
Well, this is what was contemplated by our Constitution, is that if the legislature failed to act on something that the people felt was very significant and important, then there was this mechanism available to the people to decide for themselves if they wanted to pass a new law, or in this case, amend the Constitution. And so it is really the same as saying, we're just going to, erase that portion of the Constitution that allows for ballot proposals, because there'll always be one side or the other that might not want this ballot proposal. And as long as the State Board of Canvassers has the ultimate say, we'll just never see a ballot proposal actually make its way to the voters. And obviously that's what's very, very concerning about this. And of course, again, it's overwhelmingly popular. I think it's understood by those Republicans that voted to reject the proposal and refuse to certify that it will significantly increase turnout, and that when it does, it's likely that you'll have voters who want to vote for pro-choice candidates. Most voters in this state, they don't want to be stripped of reproductive rights. And, for all intents and purposes, they really have been at this point. Obviously, we have cases that are pending in the courts right now, so there's a preliminary injunction in place. And clearly, in the event this doesn't appear on the ballot, there is still an opportunity. Obviously, there's the Planned Parenthood case. There's also the governor's case against the various prosecutors. So this could be revisited by the Michigan Supreme Court later. But I think what bothers me so very much about this, and there's a lot of things that bother me about this, but it's we heard for such a long time from the Republican Party, who is, by and large, the anti-choice party, that this is a matter that should be decided by the states. This doesn't, that the Supreme Court should never have weighed in on this for the entire country, and that, states are the laboratories for democracy, and we should allow states to make this decision. So here in Michigan, that's what people tried to do, and that's why this ballot proposal was drafted and circulated. That's why it received more support, more signatures than any other ballot proposal in Michigan history. And that's why, if it were to make the ballot, I truly believe that it would have resounding success, and there'd be no question about the fact that it passes, and it passes in very, very large number, by a very large percentage. But now I guess what we're seeing is the Republican Party, at least in our state, is saying, well, when we said this should go back to the states and that each individual state should decide, we didn't really mean that. What we meant is we just don't want to have reproductive rights at all, anywhere, and certainly not in the state of Michigan. That's the message that I think they're conveying, and is a very anti-democratic message. And let me say this: in the event that that there is a belief that this spacing issue, or the typographical issues, as it's been put by the committee that's opposing this proposal, if they truly believe that those spacing issues or typographical issues should prevent this measure from becoming law, they don't lose that ability to challenge this after it passes. I'm particularly aware of a particular ballot proposal that passed in 2004 that was called the Michigan Marriage Amendment. And I challenged the constitutionality of that with some other attorneys. And I did so almost a decade later. So you don't forfeit your right, and I was successful, as you might know. But I mentioned that because you don't forfeit your right to challenge the constitutionality of a ballot proposal, the legality of a ballot proposal. You still maintain that ability. But if you keep a ballot proposal off, then there's no opportunity to even get to that place because you haven't allowed the voters to have their say at all. And, I think that's as anti-democratic of a maneuver as I can possibly think of. And I want to say this last thing. In 2020, obviously, it was the first time for me that I really started to think of the boards of canvasser, whether they were county boards or the state board, as a mechanism that could be used instead of to allow democracy a path forward to be obstructionist in nature. And we had that situation with Wayne County, and then with the state board of canvassers. And if you remember, there was a gentleman by the name of Aaron Van Langenfeld, if I'm pronouncing his name correctly, who was one of the Republican appointees to the board. And he stood up and he said, I don't have this authority. I can't interject my judgment for that of the legislature and not for that of the voters. And I don't have the authority to say this election wasn't run correctly. The courts can say that, but I can't say that. So he voted in favor of certifying the 2020 election. Well, that gentleman received so many death threats from his own party that he was forced to vacate the office. And he resigned because he didn't want to continue to get death threats. That is such a dangerous set of circumstances. And it's one I think we have to be very aware of and careful about as we move forward into this election and into future elections. That's as anti-democratic as I can possibly imagine.
Thank you, Attorney General. Alex, I still see your hand up, but I think that you are all set. I'm going to go ahead and assume that. And I do not see any additional questions, so I want to thank everybody for their time. And if you do have any follow-up, please feel free to email me at the department, and I will do my best to get you the information you seek.
Amber, this is Amber Ed White from the Association.
I'm sorry, Ed.
Can I weigh in on something? Attorney General Nessel, the Michigan Supreme Court yesterday rejected your office's appeal on the taint team in the Flint water case. Where are you going to get the money for that task? The new fiscal year starts in a couple weeks. Your office has said it could cost $40 million. How are you going to carry this out?
Well, Ed, as much as obviously this is an important issue, as you know, there's a conflict wall in my office. So I did not have a single conversation with the Solicitor General, Fadwa Hammoud, or with Wayne County Prosecutor Kim Worthy, who are managing and handling the Flint Water criminal cases, and I'm not permitted to. So I had no discussion. I assume that, I think the statement that I saw publicly is that they intend to move forward with the process. But any of those other questions, I can't answer. But what I can do is I can ask my Solicitor General to respond to your question, and I'd be more than happy to do that.
But where is the money? I mean, you're head of the office. Where's the money going to come from? That's someone else's authority?
Well, I will say that, for instance, if there are potentially other avenues that can be explored that wouldn't cost as much money, then I don't know about that because I haven't been involved in that process at all. So it's something that, with all due respect, I'd really like to have my Solicitor General respond to, just because I can't even be part of those conversations as to what are the different ways to utilize a taint team, what are the least expensive ways, how to expedite that. I haven't had any conversations about that at all with my criminal team. And so I think it's best that they answer your question. When I erect these conflict walls, I'm very serious about it. So I haven't had any of those discussions, and that's why I'm unable to answer your question right now. But I will have my Solicitor General get back to you on this.
Thank you, Attorney General. Stella, I see you also have another question. I'll follow up with you directly. Thank you, everyone, for joining us this morning, and we're going to end now. Thank you, AG.
Thanks. Thanks, everybody. Have a great morning.